Good evening, ladies and gentlemen, Mr. Chairman. I'll try to be brief. My name is Ben Lynde. I'm Policy Counsel with the ACLU of Georgia. I join you tonight to speak in opposition of SB 523. We oppose this bill because intentionally or otherwise, we are concerned about the chilling effect on speech that the prospect of a 20-year prison sentence and a fine of up to $100,000 will have. The ACLU and the ACLU of Georgia have been a vigilant sentinel towards attacks on association and speech throughout our existences, from McCarthyism to the racist and xenophobic attacks on Muslims by government actors in the wake of 9/11, and bills targeting protests in the state. The ACLU has always stood to protect individual rights. Back in 2017, the ACLU of Georgia cautioned this body that creating an offense of domestic terrorism would inevitably lead to Georgia using this law against acts of protest. Bringing this up to note that while I wasn't here in 2017, and while we obviously had strenuous objections, I've had an opportunity to review the committee testimony from all of the bills that came up to eventually become House Bill 425. And what struck me was that there was a deliberate process across both chambers over the entire course of session, over multiple bills and multiple versions to get the definition right. And even if it was a definition we disagreed with, and we are still, very concerned about the effects that law could have, it was still a bill that people could understand. I raised that today because I think that this bill has some serious vagueness issues, both that have been addressed before, but I want to focus on a different one. I spoke with you last year regarding acts bills that were more directly targeting criminalizing protest through using other Georgia statutes. And I believe this bill has some similar issues regarding the definition of terrorism. This bill doesn't repeal or add on to Georgia's domestic terrorism statute, but instead creates another definition that seems to be based on some elements of federal law. This definition is different from what exists in Georgia law currently because it creates two felony offenses based on conduct. And one that I'm particularly concerned about is the offense created by subsection B, which provides an offense for materially supporting an act of terrorism. When I'm looking at this bill, while the Georgia law specifically cabins the conduct to certain acts and to be felonies, there's no such restriction in this bill. And under this bill, you could be materially supporting an act of terrorism, which is a misdemeanor. And so while now there is some language about violent acts, when I talked to y'all about that bill last year, I gave through a pretty good case law review of how we've interpreted violent acts, and that's a very broad brush that could take up basically any act. Walking down a street without a license and being loud could be considered a violent act under Georgia case law. Why I'm here today is I don't believe there's any circumstance where materially supporting the commission of a misdemeanor, which is punishable by 12 months in jail, could justify a 20-year prison sentence and a $1,000 fine. And in all candor, as many other speakers have spoken, the sponsor went out of his way to work with us to address this issue. But every time I tried to craft a definition that would meet the goals of the bill, it just seemed to basically create a whack-a-mole problem, but additional problems. As you all know, right now, as in Georgia, as well as across the nation, we're in times of heightened political tension and global crisis. As such, we believe that our leaders should safeguard free speech, open debate, and dissent. The ACLU has always cautioned you about these types of bills, and we've come back today to ask you to stand up for Georgians' ability to safely protest and conduct that this bill at best would chill and worse gravely imperils. As always, I appreciate your time.
Question from Senator Setzler. Thank you. Appreciate your testimony. And harkening back to 2017, I remember that effort was very, very intimately involved in that in committee and otherwise. Where in that effort, it would become a felony to block a street in a protest?
Yes.
It was a direct felony for nonviolent resistance. That was stripped out of the bill by this legislature. I don't see that here. First thing I went to look at when I saw this was, are there nonviolent acts that are invoked, and do we create new subpoena powers? That bill also had vast new subpoena powers that were pulled out. I don't see that here. So I'm concerned about the things you're concerned about. I just don't see them in the bill. Show me where they're in the bill.
Sure. So the direct line, so where this bill is just violating the laws of the state of Georgia, that's not cabined to felonies. There are a multitude of misdemeanors that allege what could be considered violent conduct. The riot statute is a really good definition of that, where it doesn't say, there isn't a cabining language of, a violent act which would cause reasonable apprehension of receiving a bodily injury. It just says violent acts. And when we looked at the case law that goes by, and I wish I would have brought some of them together, but there's one line that I really like, which is just walking through the streets chanting and cahooing and ringing bells is a violent act under one statute. And that's language that's still good law in Georgia. And so that's not in the bill, but we think that because of the addition of misdemeanors, it creates, at bare minimum, a chilling effect on speech, because why would I organize a protest and provide material support to that protest, understanding that if somebody in that protest commits what, could be considered a misdemeanor of violence, now I would be subject to a 20-year prison sentence. And so we talk about the chilling effect on speech. That is not, I don't believe, the intention of this bill, but I am always concerned about the unintended consequences and how they can impact a person's ability to exercise their right to protest.
So are you saying on line 14 involves violent acts or quote,
Yes.
acts dangerous to human life? So an act dangerous to human life
Is a separate clause.
like blocking an interstate, blocking a road. And then, of course, it's important to note, it wasn't noted by one of the earlier speakers on line 16, and it has to be that magic word at the end of line 16, and is intended to, where's the additive element?
So
Coercion, civilian population, and I'm not being hostile, I'm just trying to understand, I'm trying to put together this kind of lower end of this fact pattern and how that works.
Senator, I don't take that as hostility or any way. How I would address that is, when you look at what probable cause is, influencing the policy of a government by intimidation or coercion, just the act itself, if we're considering a violent act, that a prosecutor could consider that an act of intimidation. And because that protest was designed to influence the policy of a government, that it would qualify under this bill.
So you're saying if, again, the Dangerous Act was getting on MLK Drive out here and blocking the street.
Yes.
Illegally. Okay.
Yes.
But illegally, but blocking the street for purposes of influencing the General Assembly's actions, you're saying that becomes this, and because those two together become a felony act, it's in essence, it's civil disobedience to influence the outcome of the legislature creates this.
Right. And that's one of the things that comes out when we talk about the First Amendment and the protections that exist within that bill, that question of civil disobedience, which inherently, which can be, which can be crimes, which could sometimes be outside of the First Amendment. So it constitutionally gets a little more murky, but it's still something that the ACLU has, looking back at how protest activities happen, civil disobedience is often something that, it happens as a result of protest. And we're worried that because it's so much a part of protest activity in this country, that even if it's not the intention of this bill, the chilling effect still exists. And that is the purpose of my comments tonight.
I mean, and Mr. Chairman, I'll wrap by saying, it does say by intimidation or coercion. It's not Dangerous Act, influence government. That's more where the 2017 bill was. This is Dangerous Act and influence government by intimidation. I mean, by intimidation does have a limiting effect on this.
It could, and again, it goes back to like that lower standard of probable cause of like, is that violent act, is that by definition an act of intimidation that's meant to influence the government? I don't have an answer to that question. I don't think an answer is going to be found in the case law. And so that goes back to the chilling effect that this can have on speech until people start getting prosecuted, and then we'll know what the lines are.
All right, no other questions from the committee?
Thank you very much.